us?
Okay, we have filing instructions that are given to presidential candidates. This is off the internet, the Secretary of State website. And it has basically there the requirements. The second requirement is a natural-born citizen of the United States.
Well, I think we would agree, would we not? There's no dispute about the fact that the Constitution, whatever the definition is, that the Constitution requires that one be a natural-born citizen of the United States. That's not a dispute.
Yes.
We don't need any evidence about that. We understand it. It's a definitional issue. It's not a question of what the Constitution, what the exact words of the Constitution are. That's not.
Well, the reason why I say that, Mike, because we had before we raised the question. Well, what's the obligation of the Secretary of State? But you know, what state statute says whatever? You know, again, there's a burden.
I would suspect, Mr. that you would concede, I think, that independent of what is produced in this proceeding, since there is no dispute that Mr. Obama's father was not born in the United States and that he was never a citizen of the United States, which is a matter of common knowledge, acknowledged by the President, that if the Secretary of State adopted the position raised by the petitioners as to the meaning of natural-born citizen, that she would have an independent obligation to conclude that he was not qualified to be on the ballot, regardless of what was produced in this hearing. This is a matter of public knowledge. She could certainly take notice of the fact that his father was not born in the United States and was not a citizen. I would say, sitting here, that regardless of the evidence produced in this case, if their position on what the meaning of natural-born citizen prevails, that clearly the President could not then be on the ballot, and the Secretary of State could not certify him if indeed that definition were accepted. I assume there'd be an appeal, obviously. Of course, the matter would undoubtedly be appealed. But the Secretary of State ultimately, if that position was upheld, there's no way, I can't imagine how she could allow him to be on the ballot under that circumstance. And I think the campaign would have to agree with that. I mean, as a matter, because I understand that's not the position, the legal position. We'll get to the legal position in a moment. But I don't think we have to prove that. I mean, you know, I think there's an independent obligation on the Secretary of State in that regard, certainly, on that matter, there's no question. And I think the facts are such that if your definition prevails, that she would have to say he's not qualified. That's assuming your definition prevails. We're going to get to your definition in a moment. But
yeah, and just for the record, on the obligation of the Secretary of State not to certify or not allow an ineligible candidate on the primary ballot, there's a case of Struthers at 6NJ 565. 6NJ 565 Struthers, STROTHERS. Right? And the basic idea is that she cannot allow somebody to run if they're not eligible. Of course, Your Honor, I guess you'll read the case.
Absolutely, we'll read the case.
Yes. And also, I cited the Constitution. I didn't say it in these arguments, but the Article 2, 3A. Article 2, 3A. It's the New Jersey Constitution.
Yeah. And so you can bring it.
Yes.